Water is life, but in South Africa, where water is scarce, managing it fairly and sustainably is a big deal. So, who owns water? How are water rights granted? And what happens if people pollute or overuse it? Stick around as we break down South Africa's water laws. Hi, Root for Nature family, and welcome to Environmental Law 101, where we talk about environmental laws in just 10 minutes. It's National Water Week, so it's only fitting that we actually spend a little bit more time talking about water and what the law actually says. So in this video, I'll be breaking down South Africa's water laws, including some of the key principles and challenges we are currently facing as a water scarce country in a climate crisis. So before we proceed, just a reminder that Root for Nature is available on Instagram and TikTok. So if you don't follow us there, please head over to those platforms and click the follow button so we are always connected. So what's the deal with water? Water is a critical natural resource. We need water for our survival. Yet it is also a resource that can easily be taken for granted in pursuit of other seemingly more important development activities. Climate crisis poses a significant risk to water resources. For instance, floods and saltwater intrusion damage freshwater systems. Droughts result in water shortages which threaten availability of drinking water, agriculture, and ecosystems. Some development projects such as mining not only consume a lot of water but also pollute water resources, posing a threat to both water quantity and quality. And poor water quality and scarcity only increases inequalities, leading to competition for water resources and potential conflicts. So in South Africa, a country that is already facing a water crisis, urgent action is needed to secure a sustainable future. To adapt to all of these challenges that we are facing and the threats that the climate change poses, we must conserve water, protect wetlands, push for stronger water laws, and invest in climate-smart solutions. Now, when it comes to stronger water laws in South Africa, the environmental right in Section 24 of the Constitution and Section 27 of the Constitution, which provide for the right to access to water, are relevant. This means that any water legislation must be considered in the context of the requirements of these two rights. The regulation of water is of fundamental importance in South Africa, such that only the national government has the exclusive legislative competence when it comes to water, reflecting how it is an issue of national importance. So generally, South Africa's water governance is divided into two, which is water as a resource and then water as a human right. And we're going to be breaking down those two things in this video. So the first thing is water as a resource. This is regulated by the National Water Act of 1998, and this is South Africa's main water law. Unlike many other countries, South Africa does not allow private ownership of water. Instead, water belongs to the people and is managed by the government for public good. This is reflected in the National Water Act, which provides that national government is the public trustee of the nation's water resources and requires it to ensure that water is protected, used, developed, conserved, managed, and controlled in a sustainable and equitable manner for the benefit of all persons and in accordance with its constitutional mandate. So the key principles coming out of the National Water Act in relation to water regulation and management in South Africa are: firstly, water is a public resource that is managed by the state. Secondly, everyone has a right to access water for basic needs. Thirdly, water use must be sustainable and equitable. And fourthly, the government controls who gets to use water through licenses and permits. One of the most important things in the National Water Act is what is known as the reserve. This is found in Section 3 of the Act and refers to the quantity and quality of water that is required to firstly satisfy basic human needs by securing a basic water supply as prescribed under the Water Services Act for people who will be relying upon, taking from or being supplied from the relevant water source. And secondly, to protect aquatic ecosystems in order to secure ecologically sustainable development and the use of the relevant water resource. So the reserve is basically a central feature of water management system in South Africa. It applies to a relevant water resource. That is, it is determined for a particular water resource in terms of both quality and quantity of water. So basically, where a water resource has been identified, the first thing they have to do is to determine the water that they're going to be setting apart as the reserve before anything else can happen with that water resource, right? So the basic needs component of the reserve has priority over the ecological component. So we need to secure the reserve firstly to ensure that it actually meets our basic human needs, and then secondly to protect aquatic ecosystems, right? So we need to get those two things right. So basically, when it comes to the reserve, the decision as to the reserve will in turn determine decisions relating to water use. Sometimes the full quantity of the water in a particular water resource may be required for the reserve. Therefore, it means that that water can only be used for meeting basic human needs and for protecting the resources, but cannot be used for anything else, right? So the hierarchy when it comes to water management and water use in South Africa is, firstly, you have to determine the reserve, and then secondly, you have to consider your international obligations and your domestic requirements when it comes to water use, and then lastly, you have to then use by license. This is where you're now issuing licenses and permits for water use for different activities. The water that is then used for licensing, for example, where mining companies want to use a water resource, they have to apply for a water use license. That is discretionary. So now that the reserve has been determined and we now know what our international obligations are and what we need for domestic use in order to meet our basic human needs, the next important thing when it comes to water use management is the licensing process for water use, right? So not all water use is the same. Small-scale users like rural communities often don't need permits, but businesses, industries, and large farms must apply for water use licenses in terms of the National Water Act. It is important to note that in terms of Section 21 of the National Water Act, water use includes not only use of water, but also activities that could have an adverse impact on water resources. So generally, one will need a water use license except in situations where your water use falls under Schedule 1 of the National Water Act, which means that it has insignificant impact on water resources. So for example, if it's water for domestic use or recreational purposes, you don't necessarily need a water use license for that. And then secondly, if you have a general authorization in terms of Section 39 of the Water Act, it allows the responsible authority to authorize water use generally in a particular area with respect to a specific water resource or for a specific geographical area. And then also those people who had valid permits before the National Water Act came into force also don't necessarily need a water use license. So what's the process? To get a water use license, users must actually prove that they won't harm the environment or take more than their fair share, right? The licensing authority for this is the Department of Water and Sanitation in terms of the One Environmental System, which is something that we have discussed when we're discussing NEMA and the General Environmental Law Framework. So if you haven't watched that video, I advise you to go back and watch it so that you can get a sense of what we are doing here, because we're just building up on that. Licenses usually come with conditions that need to be complied with, right? And when a person applies for a water use license, there are certain things that need to happen in that process. For example, public participation is required by law, and here this is where you as the public can get in. You can actually submit your comments or written objections on the application before a decision is made. So if you are of the view that actually this activity should not proceed because it has harmful impacts on water resources, then when you see an application for a water use license, in that area that's going to affect that resource, then you can actually participate in that process and submit your comments. How it works is you register as an interested and affected party first, and then you submit your written comments. And then if you submit your comments and then maybe a decision is made which will result in detrimental impact on the water resource, regardless, you can also appeal this decision to the water tribunal, right? This is something we've previously touched on, so I'm not going to touch on it in this video. It is important to note here that only a person who has registered as an interested and affected party to the water use licensing process can appeal a decision. This is obviously a prejudicial provision in the law, because sometimes you only find out about these processes after they've already been concluded and rights have been granted. However, every time you see a water use application that's in your area, it's very advisable that you register as an interested and affected party as soon as you hear about it, in case you may have to take a decision to go on appeal or to follow a judicial process later. So now that we've touched on water as a resource and just laid out some legal foundations about that, the next thing is to look at water as a human right. So water as a resource is mainly based on Section 24 of the Constitution. However, water as a human right is centered on Section 27 of the Constitution, right? This is not to say that Section 24 of the Constitution is not a human right. It is. You can check out the video on the environmental right explained for more information on this. It is effectively because water governance in South Africa is split between water as a resource and water as a service. And water as a service is anchored on the delivery of the right to access to water under Section 27 of the Constitution. So in terms of Section 27 of the Constitution, everyone has a right to sufficient food and water, and the state has to take reasonable legislative and other measures within its available resources to achieve the progressive realization of these rights. First of all, a notable difference here between the right to environment and the right to access to water is the fact that the environmental right is immediately realizable, whereas the right to access to water is progressively realized. This has implications on how the rights would be enforced, as immediate realization is here and now, whereas progressive realization is over time. And it's also kept within available resources, which makes it difficult to enforce on an agent or immediate basis, because there's always that caveat. The case of Mazibuko confirms this obligation, that the constitutional rights to access to sufficient water didn't require the state upon demand to provide every person with sufficient water. Rather, it requires the state to take reasonable legislative and other measures to progressively realize the right within available resources. That is, the obligation didn't confer a right immediately to claim sufficient water from the state. This is one of the reasons why access to water is such a big issue in South Africa, with a lot of communities living without it because of how this right is framed and how it operates, right? In relation to access to water, municipalities have executive authority in relation to water and sanitation services. This means that while the responsibility for the management of water resources falls within the jurisdiction of national government under the Department of Water and Sanitation, the provision of water to households at a local level is the responsibility of municipalities. And the main legislation regulating access to water, that is water as a service in South Africa, is the Water Services Act. This act gives effect to Section 27 of the Constitution, and in terms of Section 3 of the Act, everyone has a right of access to basic water supply and sanitation, and every water service institution must take reasonable measures to realize these rights, and must, in its water service development plan, provide measures to realize these rights. So the Minister of Water and Sanitation can prescribe compulsory national standards for water service provision that municipalities and other institutions would then have to follow. And in terms of Regulation 3 of the Water Services Act, the minimum standards for basic water supply in South Africa are, firstly, a provision of appropriate education in relation to effective water use, and secondly, and most important, a minimum quantity of potable water of 25 liters per person per day or 6 kiloliters per household per month. And this has also been confirmed in case law, right, in the Mazibuko case specifically. And then also water should be provided at a minimum flow rate of not less than 10 liters per minute within 200 meters of a household, with an effectiveness such that no one is without water supply for more than 7 food days in a year. Of course, just because this is what legislation says does not mean that this is what is happening in practice, right? South Africa still faces numerous water challenges, such as a lack of technical capacity to pull off this complex and nuanced water governance system. Licenses are still granted without regard to the need of the reserve, and tools for the protection and use of water in the National Act are overly complex and technical, which often leads to significant delays in its implementation. There is a lack of compliance monitoring and compliance enforcement capacity within the Department of Water and Sanitation. For instance, a number of mines are operating without water use licenses, which is unlawful, but there's not much enforcement of the law there. So generally, there's a lack of political and institutional priority given to compliance monitoring and enforcement, and communities suffer the most. And then also, a lot of communities in South Africa are still living without reliable access to clean water, especially those in rural and informal areas. Climate change, mismanagement of resources, and corruption only makes these challenges even worse. The truth is, we cannot realize the right to access to water if there is not sufficient quality and quantity of water around to do that. Therefore, water resource protection is important. What we do at source always affects the availability and quality of water now and in future. So whatever we do in terms of protecting the resource at source also affects the right to access to water, because if we are polluting the resource at source, at headwaters, at where it is, right, then how are we going to realize the right to access to water? Because that water is not going to be clean, which then limits the amount of water that is available and also the quality of water that is available for people to drink and use. So that's why water governance is always thought about in terms of protection of water as a resource, but also protection of water is something that is then required to meet basic human needs and realize our constitutional rights. Now that we've got a little bit of a layout of the legal foundation of water law in South Africa, what can you do as an individual? The first thing you can do is to acquaint yourself with water laws and know what your rights are. Secondly, report any water violations in your area to the relevant authorities. These include illegal water use, water pollution, or dumping of sewage or waste into river systems. Thirdly, demand better compliance monitoring and compliance enforcement mechanisms from the relevant departments. Fourthly, participate in water laws reform processes. There is always going to be a call for public participation when bills or policies are being tabled, and that is a chance for you to participate. Currently, there is a National Water Amendment Bill and a Water Services Amendment Bill that was circulated back in 2024 for public comment, and it just went quiet. These two acts seek to improve water management and governance in South Africa, and the bills have still not been passed. So one of the crucial things we can do right now is to push for the enactment of these bills into law, and for this process to be taken seriously and with the urgency that it requires, particularly at such a time as this, where South Africa is not only facing a water crisis, but urgent climate action is also required. And then lastly, a simple action that you can also do as an individual is to just use water wisely. Fix leaking taps, close taps after use, don't leave water running for too long, and take shorter showers. It is a scarce resource. Play your part too. Basically, water is an important resource and we all have a right to it. Spread awareness, stay informed, and fight for fair water laws. So as we reach the end of this video, please like, share, and comment below. How is water access in your community? What are some of the challenges you are facing and how are you resolving those? I'd like to hear it all in the comment section below. Let's engage on this topic and see how we can work together to make water governance better in South Africa. Alright fam, we'll leave it here for now. If you haven't subscribed to this channel, what are you waiting for? Please hit the like and subscribe button below and don't forget to turn on your notifications so that you're notified every single time we upload a video. Until the next time, stay true, keep fighting, and keep the earth clean.